Alrighty, thank you so much for joining. My name is Kirsty Rayner. Welcome to our very first estate planning information webinar. I will start today's presentation with our usual legal blurb. That is, all of the information presented in today's webinar is for general and entertainment purposes only, and you should always seek tailored, specific legal advice suited to your individual circumstances and needs. Today, I wanted to share with you my tips, tricks, and traps concerning wills, testamentary trusts, superannuation, and the incapacity documents, powers of attorney, and enduring guardianships. So, what qualifies me to be talking to you today about wills and estates? Well, I have my own law firm here in Port Macquarie, Rayner's Lawyers. We are conveniently located above the Beach House Hotel on the town green, and we're a boutique law firm. There's 4 of us. Ed is our paralegal, soon to be solicitor. Bridget is our office manager, and Arby is our accounts clerk. Importantly, the only area of law that we practice in is wills and estates. We are very passionate about this specialised area of law, and personally, I have committed my 10-year career to wills and estates. Along with a law degree and commerce degree, I have spent a further 5 years at university to obtain my master's in wills and estates law. Okay, so why get a will? Even if you do not have a will, you actually do. And the government sets out what would happen to your assets if you passed away without a will. So if you have a spouse, your spouse would inherit everything if you and your spouse share the same children. If you have a spouse and children from a different relationship, your spouse and your children would share in your assets. If you don't have a spouse but you have children, your children would share your assets equally. If you didn't have children, your assets would go to your parents equally. If you didn't have parents, then your assets would be split between your siblings in equal shares. If you didn't have siblings, it goes down the line to grandparents, down the line to aunts and uncles, then to cousins, and at the bottom of the list is the government. So when preparing a will, we are appointing an executor. That person would organise your funeral, tell loved ones you've passed away, call in your assets, pay out your debts, and ensure that your beneficiaries get what they're entitled to. They'd also be speaking to the lawyer in order to get probate. Secondly, we're appointing guardians to look after your minor children, as well as backups in the event that your first nominated person is unwilling or unable to take on the role. Thirdly, we're going to incorporate comprehensive executor and trustee powers so that they can carry out their role in a very efficient and tax-effective manner. We will dispose of all of your assets and incorporate disposal of body wishes as well. So, what is the process for obtaining a will? It's very easy. In fact, all you need to do is complete a quick instruction sheet, review the drafts that we circulate, and we make that process easy by highlighting in yellow all of the variable information so that your review isn't overwhelming. We reconvene a signing meeting, and then the documents are held in our safe custody facility for life. All of this can be undertaken in around about 1 to 2 weeks' time. Okay. Now, if anyone has a New South Wales public trustee will, I would urge you to check the will and see who is appointed as the executor. Every single will that I have reviewed this year, the public trustee has appointed themselves as the executor, whether or not there's a spouse that could have taken on that role or children who could have taken on that role. And most of my clients were not aware that the public trustee had appointed themselves as the executor. Now, they charge huge fees for taking on this role. If you've got a $1 million, $1.5 million estate, which these days most people do have an estate that is that large because they own real estate in New South Wales, superannuation, cash, we're easily hitting 1 to 1.5 million and above. The New South Wales trustee would be charging in excess of $20,000, $25,000, $30,000 for taking on the role as executor. In addition to their fees as executor, they also charge for genealogy services. So if they need to locate a missing beneficiary, they're going to charge 5% of the assets of the estate. So again, that's another $20,000, $25,000, $30,000 working on a $1 to $1.5 million estate. They're going to charge for the preparation of the will and also the storage of the will that has been stored in their safe custody facility for however many years. Okay. Now, aside from the standard will that a lot of people have, that's usually a couple of pages in length, there's also another will known as the Testamentary Discretionary Trust will that gives clients amazing taxation advantages and asset protection advantages. So I just wanted to introduce that will today because not many people know about them and they are fantastic. So who should consider upgrading their will to incorporate a testamentary discretionary trust? I would recommend clients that have income producing assets exceeding $500,000 to consider these wills. And again, most clients do. If you have a house or you have super and cash and shares, you're easily well and above the $500,000 threshold. If you've got minor children or grandchildren that you would like to stream income through to, if you want to save on tax, or if you're concerned about asset protection. So I thought let's use a pretend family and just to show you how the testamentary trust wills operate. So in this case, we've got John and Sue, and they've got one adult child, Josh, who's married to Louise. Under a simple will, if John and Sue leave their son Josh $1 million, then that $1 million goes straight into Josh's bank account, whether he is ready to receive it or not. If Josh is going through a divorce at that time, those assets will automatically be on the table in a family law court proceeding to be sliced and diced with his wife, Louise. Again, if Josh is getting sued by an employee or a creditor, if he's a director of a company, then John and Sue's assets are up for grabs as well. Using a testamentary trust will protect John and Sue's assets from automatically forming part of Josh and Louise's family law breakdown, and it will protect it from the creditors in bankruptcy if he just happens to be getting sued by one of his employees at that time. It also has protection for grandkids. So if something happens to Josh, there's a high likelihood that Josh's will leaves everything to his wife, Louise. So if something happens to Josh, Louise is going to inadvertently inherit John and Sue's $1 million. And if Louise later repartners and potentially has children with another new partner, we can't guarantee that that $1 million will ever end up in the hands of John and Sue's grandchildren. Under a testamentary discretionary trust will, that is a bloodline legacy. So that $1 million can be quarantined and protected for John and Sue's biological children and grandchildren. There's also fantastic tax advantages too. So if that $1 million is invested, it could be expected to earn about 5% annual return. So call it $50,000 a year. That $50,000 under a simple will would be added on to Josh's annual tax return, potentially pushing him up into a higher tax bracket. Under the testamentary trust will, he would be able to stream that extra income down to his children, making sure that that inheritance lasts so much longer. So who shouldn't use a testamentary trust will? I wouldn't bother using it if you don't have income producing assets over and above $500,000. I wouldn't bother using it if you know your beneficiaries are just going to spend their inheritance and not invest it. And I wouldn't use it if you didn't have any asset protection concerns. Now, blended families are a particular interest of mine. I love helping blended family clients. They often have complex families, and it's a real balancing act ensuring that the blended family assets get distributed in a way that mitigates the chances of disputes. So some of the strategies that we use to, try and keep as many people happy are the testamentary trust wills, the life estate provisions. Life estate, a good example would be if one of the couple or indeed both the spouses own a property and they each have children from different relationships. Something happens to one and the survivor, we want to make sure that they can live in the house for the rest of their life, but also at the same time provide for the deceased's children. So if they own the property 50-50, the deceased person can leave their 50% share to their children, but incorporate a life estate clause that says that the surviving spouse can live in the property for life. So the deceased's children have that reassurance that they're 50% owners of the property. They will eventually inherit that asset once the survivor passes away. So I'm just going to let a few more people into the meeting. Okay. Alrighty. Now, one thing to know for blended family clients, if you own your property as joint tenants, which is another joint ownership structure, your property will automatically pass to the survivor, no matter what the will says. So it's really important to understand how you own the property because there's two ways of jointly owning a property. One is joint tenants, that's the most common one, and the other one is tenants in common in equal shares. If you want to be able to provide for both children and a second spouse, the tenants in common in equal shares is a property structure that a blended family should really consider. If you do not want to be tied to the hip with stepchildren, life insurance is another strategy my blended family clients will consider so that the deceased's children can just be paid out a lump sum and the survivor can inherit the whole house. Mutual wills are another clever strategy. So a blended family couple might come in, they want to entrust each other to say we're going to leave the whole house to the survivor, but on the survivor's death, the survivor is responsible for providing equally for all the children. And the mutual will says the survivor can never change their will. So under a mutual will scenario, you would have three distinct documents. You'd have a will for one spouse, a will for the other spouse, and a third document, a mutual will contract that says the wills can never be changed unless, of course, you obtain the consent of the other person or their children. Another strategy, pardon me, we'll go back, is a binding financial agreement. So maybe the survivor might want to enter into a binding financial agreement with future partners so that they can preserve the assets from their first relationship. That's just Australia's version of a prenup, really. Section 100 stat decks are another useful document in some circumstances. That's the one that sets out reasons for structuring your will in a certain way. That might be for making unequal provision or leaving someone out. It's a separate document that explains why the will is drafted in a certain way. And finally, blended families often may need independent legal advice about some of the above strategies. Now, I've seen a lot of wills in my time. Some have been prepared by other lawyers. Some have been prepared using will kits from news agencies and post offices, and some have been prepared by the will makers themselves. Now, these are the common pitfalls I see when reviewing, particularly the DIY wills. So often they're not kept up to date and they might not address the property structures. So I've seen DIY wills where recently a particular client wanted to leave his share in a property to his children, but he owned his house as joint tenants with his ex. So that's a really big problem because no matter what his will said, his property was automatically going to go to the ex, no matter what the will said. So luckily he obtained advice about his DIY will. We restructured the property so that he could leave his 50% share in it to his children to ensure it didn't just automatically go to the ex. I've seen people fill out the online will forms but not sign them. So even if you do an online will, they still need to be signed and witnessed in order to be legally valid. Failing to describe beneficiaries correctly is another big one. So putting, class gifts saying, I leave everything to or $10,000 to each of my grandchildren, but then you've got step grandchildren asking for that money as well. Failing to dispose of an entire estate. I've heard about a DIY will recently where a person had 5 children, but the DIY post office will only had space for 3 children. So she couldn't fit all the kids in, and until she received advice, 2 kids almost missed out. Void against public policy. So people saying, I'm not going to leave my estate to my daughter unless she divorces her husband. You can't do that legally. Throwing yourself under the bus. So incorporating things that really should go into a Section 100 statement, putting really emotional private reasons in the will. I would say do not put anything emotional in the will because it's like waving a red flag at a bull. Failing to account for contingencies, that is probably the number one will fail. So that is not having backups. So not having a backup executor, not having a backup guardian, so not having a contingency plan in place. Failing to consider the trust, that's a really big one. So I've seen lots of clients have these standard wills. Something happens to the will maker. They've got $2-3 million in their estate. And when they pass away, one of their children just happens to be going through a divorce at that time. And it's a real shame because something like a testamentary trust could have saved the day in that situation. You only get one chance to do a trust will, and that's while you're alive and while you have capacity. You cannot replicate the benefits post-death. people incorrectly amend their will if they've made a mistake, losing the original, that is a very big problem, very time consuming, very costly when you're trying to convince the court that the will maker didn't just rip it up with the intention of destroying it. Can be very, very complicated, those types of cases. And finally, appointing the public trustee if you do not understand how their fees and administration operate. Will disputes. So this is becoming more common as real estate prices increase in New South Wales. The chance of a will dispute has increased because people, I think, they've got more to lose. Interest rates have gone up. People are a little bit more desperate. I'm seeing a big increase in will disputes lately. Importantly, there are only certain people that can challenge your will. So that are children can challenge your will, spouses can challenge your will, an ex-spouse in certain circumstances can challenge your will. People that have lived in your household and have been financially dependent on you can challenge your will. They include classes of people like stepchildren, grandchildren, foster children. Importantly, they have a very strict timeline. They can only challenge a will 12 months from the date of death. In terms of costs, this year, the cheapest will challenge that we've had is about $3,500, and the most expensive has been in excess of $100,000. So it really depends on the attitude of the other side, the attitude of the solicitor, how big the estate is. There's a real range. You can only successfully challenge a will if you've been left out of a will not adequately provided for. So you've got to prove that you have needs. And a clever lawyer will prepare a shopping list of needs that is along the lines of, my client has a mortgage, or my client hasn't had a holiday in 5 years. My client needs dental work. So they will fluff up the needs criteria in order to get their case across the line. 80% of family provision claims settle at mediation. So that's one good thing. Only 20% are going all the way to trial and hearing. And there are a lot of misconceptions about will disputes. So the ones I've heard are, if I leave my beneficiary $1 or $10,000, does that mean they're prevented from challenging my will? And the answer is no, they can still challenge your will. Even if you had 2 kids and you left them 50-50, one of them could still challenge. And a perfect example might be you have a daughter here locally and a son on the other side of the country, say in the mines, and the parents have left their kids 50-50, but the daughter has been here on the ground taking mum and dad to all their medical appointments, to bingo, helping care for them. Sometimes 50% isn't fair, depending on who you ask. So it really comes down to whether or not the person says that they've been adequately provided for. Now, superannuation is often missed. So a lot of people have a will, but they haven't taken the time to update their superannuation nomination. And superannuation, besides the family home, is often our largest asset. So it's really important that the superannuation strategy aligns with the estate planning strategy. And there are a couple of ways you can nominate a beneficiary to receive your super. My favourite is a binding nomination. So that is different to filling out something on your app or on an online portal. Usually a binding nomination involves paperwork, and it involves you signing a document in the presence of 2 witnesses, much the same as your will. They can be non-lapsing so that you don't have to worry about updating it, but more often than not, they do lapse every 3 years, the usual retail fund ones, that is. So if you haven't prepared a binding nomination in the last 3 years, it might be the case that it's lapsed, and I would urge you to check that out. The only people that can receive your superannuation are known as cis dependents. So you can't nominate a parent to receive your super. And that's a really big mistake a lot of my young clients make. So 18, 19-year-olds, they've gotten a job, they want to do their first will because they've got that default life insurance cover within the superannuation fund, which is usually $200,000, $300,000 just without them doing anything. And they often have nominated mum or dad or their siblings to receive their super, and that is an invalid nomination usually. You can only nominate a spouse or children or someone that is financially dependent on you to receive your super. So what you would do in that situation is nominate your estate to receive the super, and you make sure you have a will and you draft into the will what you would like to happen to the superannuation. So we can get around it that way. One issue with the young clients who have the invalid nomination, and if you know anyone who could be 18, 19 or under 25 that has worked a day in their life, they've probably got $5,000 account balance, but $300,000 in life insurance. If they've nominated their parents and something happens to them and they've got a boyfriend or a girlfriend that they've been texting or potentially staying over a few nights a week, they will sometimes be able to challenge that superannuation policy and claim the whole lot over and above the parents. There's only certain people that can receive your superannuation tax-free. So that is spouses can receive superannuation tax-free, and children under the age of 18 can receive superannuation tax-free, and someone that is financially dependent or interdependent on you can also get super tax-free. The one that most people do not know about, adult children, independent adult children, cannot receive superannuation tax-free. So that's a really big one, especially for divorced clients or widow or widower clients who want their adult children to receive their super. Unfortunately, they cannot receive it tax-free. So I really urge people to get superannuation legal advice and financial advice, because you can also impact an adult child's Centrelink benefits if you nominate your adult child directly to receive the super. So that'll be treated as income and could turn off their CCS childcare benefits, but we can get around that by nominating the estate. So it's really important that superannuation is looked at when preparing a will. Alrighty, so moving on to the incapacity documents, these are, I say, just as important as a will. So all of my clients that walk into this office usually walk out with a will, a power of attorney, an enduring guardianship, updated superannuation, and a comprehensive letter of wishes workbook. I have seen what happens when people do not have incapacity documents, and you might know people that are looking after mum or dad or someone that has a brain injury or dementia, early onset dementia, whatever it is. It's very difficult when you do not have these documents in place, and I cannot prepare them when someone has already lost capacity. So I would just say when you're preparing a will, do the whole estate plan so you do not have any loose ends. With the power of attorney, there's two incapacity documents. One is the power of attorney, which is to do with financial and legal decisions. The other one, the enduring guardianship, that's to do with health and lifestyle decisions. So with the money one and the legal document one, the power of attorney, you should only appoint people you trust implicitly. And that's because an attorney is such a powerful role. They literally step into your shoes and they can go straight down to the bank. They can take all of your money out of your bank account. They can sell your house from underneath you. So you do not appoint anyone that you do not trust, and consider appointing two people. So there's a check and a balance in place. You can opt for it to start immediately, as in while you're alive and while you have capacity, or you can say, no, I do not want this document to start unless I lose capacity. We tailor draft our powers. So our power of attorney documents, they're not your ones that you could just download off the internet. They've got comprehensive modern digital asset clauses. They've got superannuation clauses. They've got gifting provisions, conflict of interest provisions. So they're really suited, bespoke documents. And you can revoke them. So if you lose trust in your attorney, you can revoke the document as long as you have capacity. Once you lose capacity, it'll be a matter for NCAT, which is the tribunal in Sydney, to be notified if someone believes someone's doing the wrong thing. Now, enduring guardianship. So this is the I'm alive but incapacitated to manage health and lifestyle decisions. So that could be whether someone is going to receive at-home care or if they're going to a nursing home. And if so, which nursing home? Is it going to be Port Macquarie, Sydney, Coffs Harbour? Whether the person will be getting medical treatment, dental treatment, if they're getting a haircut, podiatry, nails, physio, massage, all of those health and lifestyle decisions a person still needs when they're alive but incapacitated. Importantly, it covers off on end-of-life decisions. So putting in there if there was no hope of recovery, whether you would want the switch flicked essentially. And this one can only become operational if you lose capacity. No one can make health and lifestyle decisions for anyone while a person has capacity. So why prepare these documents at all? So things my clients tell me when they have these documents in place is they've got peace of mind. They're empowered, they've got certainty, and they've just relieved they don't have to head into the holidays thinking that they still haven't done these documents, or head into an operation, scared that they've got loose ends. Importantly, these documents mitigate disputes. So I can never guarantee that anyone won't challenge a will, but the chances of a will being challenged are much less if there are documents in place. And mostly people want to leave their family a legacy and not a mess. So when you do not have a will, you have to prove to the court that there is no will, and that means the loved ones asking all of the solicitors in the local area if there is a will, all of the deceased's banks, searching the deceased's property, searching the deceased's paperwork, searching the deceased's business, all while they're grieving, getting consent documents, getting stat decks, getting marriage certificates, getting divorce certificates, getting birth certificates. It's a huge, labor-intensive, very stressful process when someone passes away without a will. If someone has a will, you can have a will and a death certificate, and the asset holders will do whatever you want. So in terms of not leaving a headache, highly recommend that these documents are prepared and prepared properly so that you don't have to worry about the huge costs in time and money afterwards. So this is our last webinar for the year. Next year, I'm planning on doing more webinars about wills and estate planning documents. I've had feedback that people want to know more about the probate process. So after someone has passed away, how the administration process works, and also separately a will disputes webinar, how to fight them and how to defend them. So they'll be coming up and I'll share them on my socials, which is largely Instagram and Facebook. Now, if anyone has any feedback, we really welcome feedback. You can email us or you can follow us on our social media. And if anyone has any questions, I have a link on my website where you can book a free 15-minute discovery chat. So I'm always happy to hop on a quick phone call and let someone know if they need advice or not. But I'm not sure if I can take questions on here. I'll have a look. If anyone does have any questions, I'm happy to answer them in the chat on the right-hand side. Otherwise, I'm always happy to take it offline as well. But I hope that everyone in attendance today did get value out of today's webinar. And if so, I will make this webinar recording available and I can circulate it by email. So if you have anyone in your network, friends or loved ones, family that you think would get value out of this webinar, I'm happy to share that on to them too, and they can watch it in their own time. But I can see someone asking a question, so I'll just hang on for a couple of seconds. All right. Thank you, Kylie. Great to have you. Alrighty then, everyone. I might wrap this up. Thank you so much for your time and for taking time out of your busy day. I really appreciate it. And enjoy the rest of your day wherever you're joining us from. Take care. Bye.